When I received my license 30 years ago to practice law, I was so excited about being able to advocate on behalf of others and for their civil rights. And of course, being a new attorney, I didn't want to go with a law firm because I didn't want my hands tied and not be able to freely advocate for others. So I practiced law in other areas to keep afloat and also to learn. I practiced criminal law. I was a juvenile attorney. I practiced family law. And to practice family law, you have to be sensitive to the issues. And one of the things I learned about family law is that whether it's the mother or the father or the wife or the husband, they play games, y'all. Now, I've heard from some of you who have had issues with the father not paying child support or with the mother not allowing the father to see the children and other issues. I want to give you some leverage on how you can respond when one of the parents or fail to assert a claim to the detriment of the other party. And we're going to look at a case here where the mother delayed asserting her claim against the father to the father's detriment. So let's get started. Laches is a doctrine in equity whereby courts can deny relief to a claimant with an otherwise valid claim when the party bringing the claim unreasonably delayed asserting the claim to the detriment of the opposing party. And because of this delay, the claimant is no longer entitled to bring an equitable claim. And we're going to look at the case Charles N. Bassett versus Denise Bassett. Before we do that, let's define the term delay in the context of Laches. Delay alone in asserting a right does not constitute Laches. Rather, one must show that he or she has been materially prejudiced by the delay of the person asserting the claim. This quote comes from the Bassett case. Length of time in asserting a claim does not in itself satisfy a showing of material prejudice. Material prejudice is shown by proving either one, a loss of evidence helpful to the defendant's case, or two, a change in the defendant's position that would not have occurred if the plaintiff did not delay in asserting his or her rights. So there are three issues I want to hone in on and discuss. The first issue is that the defendant was denied his visitations. Now, Mr. and Miss Bassett were married, and in 1978, they had a child named Gia. They divorced in 1979. The court ordered that Mr. Bassett pay child support, and that's common, right? However, between 1979 and 2000, Mrs. Bassett prevented Mr. Bassett from visiting with their daughter, Gia. And as a result, Mr. Bassett changed the way he made child support payments, which is the second issue. Mr. Bassett eventually ceased paying child support directly to his former wife. Instead, he placed the money in a separate savings account. And this took place between 1979 and 2000. And as a result, the Trumbull County Court of Common Pleas held Mr. Bassett in child support arrearages. On August 3rd, 2000, Mr. Bassett filed a motion with the trial court requesting that it discharge any arrearage he owes to his ex-wife on behalf of their daughter, Gia. Now, the Child Support Enforcement Agency got involved and attempted to assist his ex-wife in getting the child support. In fact, in 1998, the Child Support Enforcement Agency contacted the ex-wife, and she did not want to collect the money. Again, in 2000, the Child Support Enforcement Agency contacted the ex-wife. Prior to 2000, the ex-wife was silent on the issue. Trumbull County Court of Common Pleas denied Mr. Bassett's motion to discharge his child support arrearages. Mr. Bassett appealed to the appellate court, and the appellate court reversed the trial court's decision. So let's listen to the court's order opinion. The appellate court ordered that the trial court abused its discretion by not applying the doctrine of Laches to bar appellees, who would be the ex-wife, claim for a child support arrearage. The judgment of the Trumbull County Court of Common Pleas, Domestic Relations Division, is reversed and judgment is entered for the appellant. And in this instance, the wife is the plaintiff appellee and Mr. Bassett is the defendant appellant. And here's the opinion. In the instant case, appellant began placing his support payments in a separate account on the advice of counsel. Appellant did so after appellee continually denied appellant visitation with Gia. Eventually, appellant claimed appellee concealed her whereabouts and that of their daughter to prevent appellant from exercising his right to visitation. Appellant did try to enforce his visitation rights with Gia until appellee concealed the whereabouts of the child for a period of time. That concealment resulted in appellant's counsel deciding not to file a motion to terminate or suspend his child support payments, as then permitted by statute. Appellant was prejudiced by appellee's failure to pursue collecting the child support at that time because he lost his statutory right to terminate support for interference with visitation. Appellee, the appellate court continued, never sought to enforce the child support order before Gia's emancipation. The Child Support Enforcement Agency admitted it then should have issued a termination notice ending its efforts to collect the arrearage. The Child Support Enforcement Agency's failure to issue the notice led to the renewed inquiry regarding the arrearage in 2000. Appellee never pursued the collection of the child support arrearage until 2000, when Gia was 22 years old, and only after the Child Support Enforcement Agency contacted appellee again about the child support arrearage. No doubt some of you find yourself in a similar situation. It's not easy. I got it. I understand. But let me say this, whatever side you're on, do what's right, because not only is your well-being in jeopardy, but the well-being of the child or the children is put in jeopardy. And if you are parents and you just can't work out your issue for the sake of the child or the children, be civil, because your child or your children are watching, and your conduct, it does affect them one way or the other. And those of you who are involved in a situation such as this, I hope this video give you some solace to resolve your issues in a way where everyone who is involved or connected, their well-being is intact, okay? I hope that this video has been helpful to everyone. I am Advocate Lucinda, and we will see you next time. Take care.